Okay, Assalamualaikum and good afternoon. Hello, students. Can you all hear me?
Yeah, good afternoon, Doctor.
Yeah, Waalaikumsalam.
Okay.
Yes, madam.
Yeah. Okay, so it's raining here. It's raining in Kedah. So I'm not sure about your states, where you are living. How's the weather there? Is it raining?
Yes.
Yes, madam. Boleh tu.
It's raining. Okay, I see student leaving the meeting. So the class has just started. Please do not leave. Okay, I saw one student leaving. I'm not sure why. Okay, so please, if you do not listen to the lecture, you will not get the knowledge. Okay, so please stay here until the end of the class. Okay, so hopefully everyone has taken lunch. Okay, so and hope that you are in good health, because tomorrow is Friday and then it will be like weekend. Okay, so you can of course you are staying with your family, so it doesn't make you feel very lonely. Okay, so I will start the class today on the employment relation or industrial relation. Okay, so the industrial relation actually exists between employer, employee, trade union, and also the organization. Okay, that's why we have the industrial relation or employment relationship. Okay, so why we must have a good relationship between the employer, employee, and also the industry. Okay, so you can see here is to create healthy and harmonious relation between employees and employer. Okay, then it will minimize industrial dispute. So when both parties, employer and employee, are in good what do you call in good relationship, it will reduce. Okay, um it will reduce, okay, industrial disputes. Okay, so for those who are using extra mics, I think you have to switch off because I'm hearing noises. Okay, I'm not sure who is actually we have not off the microphone. I think okay, yeah, now okay. So when the relationship between the employer, employee, industry, and also with the government is good, so it will improve productivity, okay, and also will provide workers their appropriate position by considering them partners and associate to the management. That means they will be appointed later as a supervisor, senior supervisor. Sometimes they are in the board of directors. Okay, so they will get a good position. Okay, and also some workers okay, will have profit sharing okay, and it will also improve the working condition. Okay, and at last it will reduce the chance of strike and also lockout. That means no picketing, no strike, and also lockout in the workplace. Okay, so now, okay, now the employment relationship has become one of the most delicate and also complex problem in modern industrial society. Okay, because employees, you cannot call them as servant. In those days, we have servant and also master. Okay, so the master will be the employer, the servant will be the employee. Yeah? So but now we call them as employee and also employer. Okay, and you must maintain a good relationship with the employees as an employer. Okay, so industrial progress is impossible without labor management cooperation and industrial harmony. Okay, therefore it is in the interest of all to create and maintain good relation between the employer and employees. Okay, so if you are working in any workplace, you have to be a good employee, and you have to obey, okay, the employee, and this is where you got your duties towards the employer. And at the same time, the employer also have the responsibility and also the duties towards the employer. Okay, so this will help to maintain good relation between the employer and also the employees. Okay, so have anyone here experienced working before um, um, joining UUM, or you do part-time job? Okay, anyone have experience being an employee here? Any students, you got experience being employee or being employed by someone? Yes, okay. Yeah, now Nurul, okay, or maybe Matura, okay, so many, yeah, okay. So, um, are you being treated well by your employer? How's the treatment? Do you get pay, salary, um, every day or monthly? Let me check here. Maybe here, uh, monthly, yeah. So Tan Bing Hoi says that been paid monthly, yeah. Okay. So uh, did you get any holidays or public holidays or weekly rest day? Weekly rest day means like Saturday, Sunday, or Friday as your rest day. Who's Nor Asira? Did you get any leave from your employer? How about Muhammad Faiz? Did you get any leave from your employer? Oh, you got 1 day, per week, okay. Or the other one, Asra, saying that she got Saturday as a week days. Okay, so it's very important, okay, to get rest day. But now you know rest day can be 2 days, Saturday, Sunday, or maybe Friday and Saturday, or it can be any days. It's not necessary your rest day must be on Saturday and Sunday. It can be any day, Monday, Tuesday, or it can be any day. You can choose the day. So the employer can choose any day, but he must inform the employee first. Okay, so you must be treated with what you call due respect as an employee. So you are not servant to your employer actually. Okay, so now you will see the relationship. We will study the duties of both party, and also the nature of the duties. Okay. So in employment relationship, okay, so we study constituted law actually. Okay, so the employment relationship actually regulated by Employment Act and also Industrial Relation Act. So the Employment Act describe the term contract of service, and the Industrial Relation Act use the modern term, that's the contract of employment. Okay, so to be an employee, you must be in contract of service. So in next lecture, that will be in next week. Okay. Um, 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 I will give you an article to read. Now, why is it important to be in contract of service? Okay. So your relationship with your employer must be in contract of service. Okay. So maybe you cannot understand this because the test is in next the test to determine whether you are in contract of service, it will be taught in next class. Okay, so who is an employer? An employee according to our Malaysian law. Okay, so we have two definitions from Employment Act and also Industrial Relation Act. Okay, so the employer is a person who has entered into a contract of service to employ any other person as an employee, and it includes the agent, manager, and factors and others. So you might not be calling your employer as a employer, but he can be an agent, he can be a manager, he can be a factor. Okay, so these are the different names that we can call on a, the term can different term can be used instead of calling a person as an employer. Okay, so a person who has entered into contract of service to employ. That means you are going to employ a person, okay, as an employee. Okay, so you are the employer. Okay, so who is an employee? employee is a person or class of person in the first schedule. Okay, so you have to refer to the Employment Act to know who are the employees. Okay, so in the Employment Act, there's one schedule which we call as first schedule. Okay, so the first schedule have two classes. Okay, so the first schedule mention about the first class. Okay, sorry, the first schedule mention about the first class. Okay, the first class is any person irrespective of his occupation. Okay, here the occupation is not important. Whether you are supervisor, you are what do you call maybe what do you call maybe a tuition teacher, okay, because it is a private sector, okay. But who has entered into contract service with an employer and whose wages do not exceed 2,000, okay. So the Employment Act applies to a category where, okay, the employee must have salary below 2,000, okay, excluding commission allowances and overtime. Okay, so you know our minimum wages is how much? So it's above the minimum wages is 2,000, but it will exclude. So your commission might be like 500 or maybe allowances 300. So that will be extra, but your wages must be 2,000 and below. So you are an employee under the Employment Act. Okay. Then the second category. Okay. Can you all hear me? Hello.
Yes,
Yes,
Okay. Okay. Because I see no one no videos of yourself. Okay. Okay. Then the second schedule. Okay. Second schedule is where um it is any person who is employed by the employer, but the amount of salary is not important. That is irrespective of the amount of his monthly wages. Okay, but he have entered into contract with service. That means he have entered into a contract with the employer. Okay, so he is manual labor, or he can be engaged in supervising other employees, okay, engaged in manual labor, or he's in charge of operation of any vehicle, that means like drivers, okay, or in registered vessel or domestic servant. All these are the category where the amount of salary is not important, okay. So it can be below 2,000 or it can be more than 2,000, okay, because the amount is not important, but he must be in this category, okay. You know, like domestic servant, they are also employees where their salary is below 2,000, okay. Then we can see here supervisors engaged in supervising any other employees engaged in manual labor, okay. You can see supervisors sometimes they are paid 3,000, 4,000, so they are also employees, okay. Or you are engaged in operation of any vehicle, you know, those who drive containers, okay, heavy vehicles, they are paid 4,000 or maybe 5,000 per month. Okay, so they are also um, um, employee, okay, under the Employment Act. Okay, so we just look at the definition only. Okay, so we have looked at the Employment Act, what is meant by contract service, who is employer, who is an employee. Okay, now we look at Industrial Relation Act. Okay, so Industrial Relation Act give the definition of a contract of employment. Okay, so the term used in Employment Act is contract of service. You can see two different terms are used, but it give the same meaning. So it is a contract or an agreement, whether oral or in writing, whether expressed or implied, whereby one person agrees to employ another as a workman. Okay, so the word used is workman, not employee, in the Industrial Relation Act. Okay, and that other agrees to serve his employer as workman. Okay, so you can see the definition, contract of employment in the Industrial Relation Act. Okay, so any agreement, you can make an agreement with your employee in oral or in writing. Oral means there's no contract. Writing means there's an agreement, express or implied. Okay, you can look at the definition later. What mean express? Express means written. Implied means is understood by writing, conduct, and others. Whereby one person agrees to employ another as a workman and the other agrees to serve his employer as a workman. Okay, so this is a definition under the Employment Act. Okay, and the meaning of employer under the Industrial Relation Act is any person or body of person. Okay, you can say any person or body of person, whether corporate or unincorporated. That means it can be a company or not a company, who employs a workman under a contract of employment, and it includes governments, any statutory authority, otherwise unless otherwise expressly stated. So the Industrial Relation Act also applies to the government. Okay, um, government bodies and also statutory bodies. Okay, so the employer here can be a statutory body, like Majlis Pemandaran, okay, or council, town council. Okay, and it can be also government, okay, the government itself. Okay, so who is an employee? Nur Izzah, are you leaving? I see students leaving the meeting. Why is it? We just started the class. Let me check how many participants. 55, but I saw 2 already leaving. Okay. So workman means any person including apprentice. Apprentice means that you go for training. He can be also an employer. A workman employed by an employer under contract of workman. Contract of employment to work for hire or reward. So if you're a workman under the Employment Act, you can also work for training. I mean, to get knowledge, to get what you call skill from your employer, where you can pay, okay, or you can get any reward. Okay, so and for the purpose of any proceeding in relation to a trade dispute, okay, trade that means if you got any case relating to any dispute between your employer, the workman here, okay, can be who has been dismissed. Even though he been dismissed, he's still an employer, okay, or discharged or retrenched in connection with or as a consequences of any dispute. Okay, so if you've been dismissed by your employer, you are still a workman until the court decide your dispute. Okay, so you can see the difference. Okay, then who is an employee? Okay, so since there's two terms, contract of service and also contract of employment. So it is actually made between the employer and employee. Okay, so you must be in contract of service or contract of employment to be an employee. Okay, but if you are in contract for service, okay, contract for service means contract untuk perkhidmatan. Okay, this is where a party contract to provide services for another party. They are called independent contractor. Okay, they are all self-employed and they are not an employee under the Employment Act, so they are not entitled to any benefit as an employee. Okay, so that's why it's very important for us to know whether you are an employee or not. Okay, so any question? So we already completed this first part to look at the definitions. Who is an employer, who is an employee, and what is contract of employment or contract of service. Okay, so the test we will be looking in next week, in next class. Okay, so any question before we look at the duties?
Madam.
No question.
Madam,
Yes.
about the employee is definitely the self-employed type, right?
Employee.
Employee, they are always
Employee.
self-employed, right, in Industrial Relation Act.
Employer or employee.
Employee.
Employee is not self-employed. If you are a self-employed, you are in contract for service and you are not an employee. Okay. So we will look at the test later in next class, because even though you are employed as an employee, let's say an employer employ you, okay, asking you to do work, okay, he said that, okay, I will ask you to renovate the toilet, okay. So she's doing all the work, and while doing some renovation to the particular place, okay, he got injured, okay. So can he claim from his employer? Okay, that's the issue. So when it comes to a legal issue, okay, can he claim? So the court will look whether he is an employee or not. Okay, so in that situation that I gave you, okay, it's very clear that he is, okay, he come here, or he goes to the place to provide service to another party. So he's a independent contractor. So if he's injured, he's not entitled to get any compensation. Okay.
Okay, thank you,
So
madam.
that's why it's very important to know a person is an employee, not okay. So next week I'll give you an article to read all the tests in that particular article, okay, and see and you will know why it is very important to know a person is an employee or not. Okay. So now we look at another topic. Okay, so you can assume that you are an employee, okay, then you will see what are the duties, because the test will be later. Okay, so what is the rights and duty of an employees? Okay, so um, um, before that, okay, I will let you know that normally when you are engaged as an employee, okay, first you will get a letter of offer and then you will make the acceptance. That's the proper way actually. Okay, your employer will give you a letter, okay, saying that you are offered maybe as a legal assistant, okay, and the salary is so much, okay, you have to work from what time to what time, and what are your rest day, and other terms and condition, and you make the acceptance. Okay, acceptance is penerimaan, offer is tawaran. Normally you get the, even to come to also you get the law offer letter, and then you make the acceptance whether you want to come and report or not. Okay, so once you do this, there's an agreement between you and the employer. So it's the same. You have an agreement with the university, because you already accepted the offer to be a student. So all the rules in will apply to you. Okay, so it's the same with you and your employer. Okay, so any rules and condition in the workplace that he make will apply to you. Okay, and you also must have a legal capacity. Okay, legal capacity, that means you must have the qualification. Okay, let's say to be a legal assistant, you must have the qualification in law. Okay, or you want to be an accountant, you must have the legal qualification in the accountancy. Okay, and it's the same. To be a student at you must have the qualification, okay, set by the university. Okay, and the consideration is that you've been paid salary. Okay, you paid salary and then you get the allowances, you get bonus, you get consideration can be anything. Okay, it can be the sick leave, maternity leave, all these are consideration. In Bahasa we call this as balasan. Okay, so like in university, okay, the university will provide you the knowledge. You get because you make an agreement. Okay, they will make the exam for you. They have to do online classes. All these are the consideration. Okay, and it must be a lawful purpose. Okay, so as a employee, you must engage in lawful work. Okay, you cannot do or involve in a trade, like trade involving in drugs or maybe falsifying documents. Okay, those are illegal. Okay, so you must make sure your job or your work with your employer must be a lawful. Okay, lawful according to the law. Okay, and you must also have the freedom to contract. So that means your contract between the employer, okay, cannot be influenced, okay, or cannot have element of duress. Okay, you artinya you tak boleh dipaksa untuk memasuki kontrak dengan majikan. Okay, so freedom is sukarela. Okay. Okay, so these are the elements to make a contract between you and employer. Okay, so the contract that you make with your employer is actually a legal relationship comprising certain rights and duty. So the employer cannot write down all your duties because some of the duties are implied. Okay, so but if there's any breach, the party, the aggrieved party, um, have a legal cause of action. Aggrieved party means the pihak yang kecewa. Okay, that means let's say you've been dismissed, of course you are the aggrieved party. So you can take action against your employer. Okay. So now we will look into some of the duties. Some of the duties we can say these are the implied duties because when the employer engage you, he will not let you know every single thing. These are your duty. Okay, only the main duty he will let you know that you must come to work at before 8. You must punch and then you cannot leave. Okay, unless with the permission of your employer. Okay, and you must take maybe your lunch in a area that is within how many kilometers so that you can come back to work after your lunch. Okay, so the employer can set certain certain rules. Okay, so that will be your duties. Okay, so implied duties are unexpressed duty. Unwritten is not written by your employer, but the law says that you have these duties. Okay, so um, here we have some. So the duty can be like to serve your employer faithfully, diligently, honestly. So the employer will not tell you, okay, do not steal any of the company's property. You want to take a pen, you must get a permission unless you are given stationery. Okay, you must be faithful to your employer. Okay, that means during working time, you must concentrate with your work. You are not allowed to use WhatsApp or you must put away your phone. So that's what you call implied duties, where you must be faithful. Then to obey his lawful and reasonable instruction. Let's say he give any instruction, you must obey his instruction. But at first, you must make sure that his instruction is lawful and reasonable. Adanya yang sah dan juga munasabah. Okay. Then you must keep information about your employer's affair confidential. That means anything to do the business. If there's any profit, let's say your employer in the meeting says they saying that this year they got profit so much. Okay, and if there's any loss, they also mention in the sometimes in the meeting. Okay, so whatever information regarding your employer, which is deemed to be confidential, you have to keep. That means you cannot reveal. Okay. And then you also have to perform work with appropriate level of care and skill. Okay, that means of course before you have been engaged, there's an interview. You've been engaged. You are appointed. Then you have to do all your best to work at the company. That means that if you think that you are not good in certain skill, you can also go for training. Okay, because you are required to work at the appropriate care and skill. Okay, so these are the certain duties. There are so many duties. Okay, um, we just look at the important ones. Okay, so anyone can share any of the duties. Okay, or you want to let me know, or you want to share with your friend other implied duties that not be listed here. Any other duties that you think the employee should have? Employee should have any duties? Here I already just put some of the duties. Okay, and you just mention any other duties that you think the employee should possess. Amirul, sorry, Amir Rahman. Amir Rahman. Yeah, responsibility. Can you name? You must be responsible. Responsible. Okay. Any other duties? Implied duty. Haikal Hakimi.
Yeah.
Implied duty be fair. Yeah, Haikal. Did
Yes.
you want to share any duty that you know? Uh-huh. Respect each other. Apa um, tanggungjawab seorang pekerja yang tidak ada di dalam slide ini yang ingin dikongsi oleh pelajar. Haikal? Don't mind because all most of the students here are Malaysian and we got one foreign student. Okay. Is it Firdaus? Firdaus? I couldn't get your name here. Firdaus. Firdaus, can you mention one of the duties? Okay, we got another student saying loyal. You must be loyal to your employer. Okay. Okay, so or other simple duty like you cannot sleep during working hours. Okay, yeah, to perform well. That means you must perform according to appropriate level. Okay, here Tuan Muhammad Faris says that to respect to the order from management. Yes, you must obey instruction from your management. Okay, so you can see, okay, to take care the property of the employer. Okay, so we can see few other duties. So we got here because the list will be very long. Okay, so we'll just look some of the duties. Okay, so if you are interested, you can also read cases. Okay, for the duties. Okay, so duty to serve faithfully. Okay. That means you must be faithful to your employer because the relationship between your employer and employee is one of trust and confidence. So every employee shall serve his employer faithfully. Okay, so you must be very faithful to your employer because sometimes you are in charge of money, sometimes you are in charge of the property, you are in charge of the business. Okay, so if you fail to perform your duty properly, it might make the employees suffer. Okay, for monetary in monetary form. Okay, so any serious misconduct which is inconsistent with the duty of faithful service may amount to a breach of contract. So faithful means jujur, kejujuran. So it's you can interpret in many words. Okay, how to be faithful. That means, like example, it can be persistent lateness. If you're coming late always, like half an hour, 10 minutes, 20 minutes every day, so you are actually not faithful. You actually you do not realize that. Okay, so is you are actually not faithful to your employer. Okay, you are incompetent. Okay, when you apply for the job, you say that your qualification is so and so. Okay, and you can do whatever work that he give you. But when you are appointed, okay, you say that you are not good at this and this. So it shows that you are incompetent. Okay, so you that also is faith. You are unfaithful because you actually not competent. Okay, but you say that you are eligible to apply for certain job. Then willful neglect. Okay, so willful neglect means you are negligent. Okay, you must take care of the property of your employer, but you are negligent. Okay, so sometimes you cause damage to the property of your employer. Okay, then theft of the employer's property is also not faithful. That means you should be faithful, but you sometimes use things, okay, not according to the appropriate manner. Okay, sometimes you make a waste of the employer's property. Okay, so these are the examples of faithful, unfaithful. Okay, so now we look at cases. Okay, so the cases are actually English cases. So for duties of employer and employee is like what do you call is universal. So every country in the world will have roughly this about the same duties of employer and employee. Yeah? Okay, so here um, the case is okay. Sim. I can't see properly. Okay. Um, okay. It's an English case. Sim versus Rotherham Metropolitan Borough Council. Okay. So in this case, it was held that the contractual obligation of a person employed in a profession capacity were those defined by the nature of his profession, and the obligation incumbent on those that follow that profession. Okay, so even though the it's very simple, but it's very meaningful. Okay, it says that you want to know what is a person's contractual obligation. You must see um, the person is employed in what profession capacity. Okay, so you look at a profession, then you will know. Okay, because it is in the nature of his profession, the obligation incumbent on those who follows that profession. Okay, so example is that, let's say you are maybe a doctor. Okay, so you want to know what is your contractual obligation towards maybe you are employed as a medical center. Okay, as a doctor you are employed in a medical center. What is your profession capacity? Okay, what are your duties? You want to look at your obligation, so you must look at the profession. Okay, the profession that the people that follow that particular profession. Okay, so can you name some of the duties of some of the duties of a doctor? Maybe um would like to say any of the duties of a doctor. Ramya, Ramya, can you mention one of the duty of doctor? Everybody is keep quiet. To examine patient. okay, and to give a medical receipt. Okay, so a doctor, okay, so a doctor must examine patient. Okay, Nurul saying that the doctor must prescribe medicine. Okay, so so you want to know because the the medical center that employed the doctor cannot mention every detail of the doctor's obligation or responsibility or duty. Yeah? Okay, so they will look at the profession of a doctor. So a doctor must examine the patient, must prescribe the medicine, okay, and he must do operation when it is necessary, okay, and he must follow up with the patient when it is necessary, okay. So there's many duties of a doctor, okay. So you must look at the profession, okay. It's defined by the nature of his profession, okay. If you are a teacher or you are an engineer or you are a nurse, okay, you must look at the profession, okay.
Madam,
Then another case, yes,
for the case
yes,
just now, right?
any question? Yeah.
Is it means that
Mhm.
anyone have a right to know their job responsibilities?
Okay. Um, this the previous case says that, okay. Okay. So if you are employed in a profession capacity, yeah, so you must look at the nature of the profession. Okay, what profession you are. Okay, so the employer cannot what do you call outline every single obligation of the employee. Sometimes he mentioned in general, these are the duties. Okay, so other than that is implied. Implied means tersirat. Okay, you must look at the profession capacity a person is employed. Okay, so being an employer is better to detail out the duties. So when you detail out, it will be express. Okay, it will be expressly stated in the contract of employment. Okay, the duties, especially when you want your employee to do certain work. Okay, you want to let him be clear what is his job scope. So it's better to outline his duty. Okay. So it's the employer's duty actually to
Okay, thank you,
outline
madam.
the job scope or job specification. Okay. Okay. Thank you. So another case says that also English case. If an employee fails to perform part of his duties, but indicate that he is prepared to perform the remainder, okay, the employer may make it clear that he is not prepared to accept such partial performance, okay, and may lawfully refuse to pay the employee the whole of the remuneration due. Okay, so let's say you are an employer, okay, your employee, okay, um, you know, um, maybe she's employed as lecturer at a private college. Okay, the particular employee is employed as a lecturer at a private college. Okay, so the employer letter of appointment, okay, says that she been appointed and she's in charge of the class. Okay, so the employer cannot outline every single duty of the particular lecturer. Okay, but he came to know that this lecturer, okay, can can conduct a class, but she do not give any exam. Okay, because she do not like to do the marking. Okay, so the employer must make sure that, okay, um, or must tell the employee that he have duty to give a lecture. Okay, then he have duty to do assignments, so that student will do the assignment and he have to do the marking. Okay, or make sure that there's online classes, or must at least do video for the students. So the employer must make it clear, these are the duties. If you do not do, okay, or you just do the partial performance, okay, as an employer, he will not pay the remuneration. That means will not pay the salary. Okay. So if you see any employees not doing the work, or only performing part of the duties, you must make sure that they know, okay, that they must do the duties okay, partial performance of the duty is not accepted. Okay. And these are by cases. We are looking by cases. Okay. Then duty to obey instructions and reasonable order. Okay, so employee undertake to obey all lawful and reasonable orders. Okay, like this is an old case, UK Atomic Energy Authority versus Claydon. The employer's contract required him to work anywhere in UK, so he refused to transfer to another base, so he was dismissed. So the the court held that the order was lawful and reasonable, for it was within the express term of the contract. Okay, so like in now, okay, you got the COVID what you call pandemic. Okay, so if you asked to transfer to let's say Indonesia, okay, can you refuse to transfer to another base? So the court will look whether the order was lawful and reasonable or not. Okay, or is it stated in the contract of employment? Okay, so the order that the employer give must also be lawful and reasonable. Okay, so if the employer do not want to obey the order, okay, he can show that the order is unlawful. Okay, let's say the order to falsify some record. Okay, so he said that he cannot do because it's against the law. Like in this case, Morris versus Hanley. Okay, so the court will look whether the order is unreasonable or not because it's a question of fact. Question of fact means satu persoalan fakta depending on what is the situation. So the court will look at the question of fact. Okay, and then we got also other old cases. These are all old cases, English cases. Okay, um, Ottoman Bank. Okay, here the court says that the employee did not obey an order which would expose him to the risk of danger to life and also liberty. Okay, so if you know that if you like now because of the pandemic, okay, you are asked to go to maybe to China, okay, you can refuse to obey, okay, because you know that it will be a risk to his life. Okay. Okay, so other thing is that duty to use skill and care. Okay, so as an employee, you have to perform your duty with using reasonable skill and care. Okay, and the law says that this must be combined with the employer's duty to provide all necessary assistance. Okay, if the employer has done all he can, then a dismissal for incompetence will be fair. Okay, so for incompetency, okay, the court says that when the employer, okay, detect the employee is not competent, okay, he must provide training. Okay, so the employer is under the duty to provide training. Okay, so after training, the employee cannot perform, okay, well, then the employee can dismiss him for incompetency. Okay, so others will be like bribes and cigarette bribes and commission. Okay, so you cannot take bribes or commission. Okay, only salary from your employer. You must know that. Okay, but if there's a tips given, okay, you can take tips. But tips is not a bribe. Okay, normally tips are paid in which industry? Students, tips are paid in which industry? Hotel, okay, Firdaus, okay, correct, okay, hotel industry, okay, because tips where tips are collected, later it is distributed to all the employees in the hotel industry, okay, so tips are recognized, it's not a right, okay, and we got confidential information, okay. So confidential information is any information regarding the employer's business. So you cannot give to any person. Okay, because you are an employee, you are employed, okay, you have to work for your employer, you must be faithful to the employer, okay, so you cannot give confidential information to other person. It can be on the profit, okay, it can be on the new design, model, mode of operation, or anything relating to the business. Okay, so you must be very careful because we got cases on this. Okay, that is an old case. In Malaysia, we got one case, and I think there's other new cases also. Okay, Smith Scientific Sendirian Berhad versus Ong Han Swan. So in this case, there was the court says that there's an implied duty. Okay, implied duty that prohibit the employee from using any confidential information, okay, without the employer's consent for his own or other person, someone else use after the employment contract end. Okay, so you might take the confidential information, you might use for yourself or somebody else use. Somebody else means like you can be for your spouse, it can be for your friends, or it can be for the relative. Okay, so you cannot do this, and it's an implied duty. Okay, okay. The court in the same case says that the trade secret are not limited to manufacturing process or cigarette formula, but extended to information relating to list of names, addresses of the customer, suppliers, scientific questions sent to the customers, cost, specific needs and status on the negotiation with the customers. Okay, I think there are cases on making like candy. Okay, got a recipe, and you resign from the company and you make your own candy, and then cupcakes also. There are cases where the court decide it is a breach of trade secret. Okay, then okay, duty of faithful. So it can be on secret, like on the businesses. Okay, like on the recipes, on the profit. Okay, formulas and others. But here's another case about the attitude. Okay, this case is where Pang Lin. Okay, where the claimant was employed by the company as a financial analyst. She was working with a bank, and she wanted to apply for a personal loan. Okay, from MBSB is the name of bank. Okay, so the company was not satisfied when the company came to know that she has falsified the signature of the HR advisor. Okay, she falsified the document, artinya tiru tanda tangan. Okay, so the claimant now contacted that her dismissal has been without just cause and excuse. So she is a financial analyst. Okay, she have forged the signature of the HR advisor. Okay, because she want her personal loan to be approved. Okay, so that's the facts. Okay, so the court here decide. Okay, um, on the behavior. Okay, the fairness or unfairness of a dismissal is to be judged by the objective standard of the way in which a reasonable employer in those circumstances in that line of business would have behaved. So since she's employed in a bank, okay, so the court says that the claimant has been involved in financial transaction involving company, and a high standard of care and conduct has been accepted from her. Okay, so the qualities of good faith and loyalty towards an employer, essential qualities of a workman. Okay, so the court says that her dismissal, that means her pemecatan, okay, her dismissal was fair in this case. Okay, so the same case here. Okay, you can read. Okay, then this is on moonlighting. Maybe you have not heard about moonlighting. Okay, so moonlighting is where an employee is working with two employers. Okay, two employer means maybe one will be his full-time employment and the second one will be part-time employment. Okay, so that is also not prohibited. That is prohibited under the employment relationship. Okay, so here in this case, okay, Gray versus CP Pembroke, the employer agreed not to be engaged in any other business without the written consent of his employer. Okay, so he took a part-time job with the rival employer. Rival means majikan yang bersaing in the same business. Okay, so his dismissal was fair as being a breach of express term of the contract and breach of fidelity. Okay, so you cannot work with two employer, okay, so unless the employer allows you. That means you must get the consent of the employer. Okay, so we have completed the duties of employee. Okay, so do you have any questions? Any question?
No, madam.
Alisha, you said no question. So the duty, okay, the duty of employer and employee is very clear. Okay, so we got few more slides on the duties of employer. Okay, this is duty of employee. Okay, how many minutes more? 3:33. Okay, we take about 5 minutes break and then I will finish up the another slides, another topic. Not much slides because next Monday I have to attend workshop. Okay, Monday, and then on Thursday is a public holiday. Okay, so we will be missing class, but I will give you some work. Okay, on the test of contract service. Okay, then I also will send after the class will send to you the post the what do you call how to look for case. Okay, so that you can do some work for Monday and also on Thursday. At least you got some work, got something to do. Okay, so I will take about 5 minute break. Okay, don't go away. Okay. So now we look at the duties of employer. Okay, so employer has certain duties. So the duties here is not comprehensive. So you got more than these duties. So we will look at some of the duties. Okay, first duty is to provide work. Okay, then to pay compensation, to take reasonable care for the safety of the employees. Okay, to reimburse the employee for any for any expenses properly incurred while at work, and also to write references. Okay, so um, the duties of employer, okay, which has been imposed by the law and also which operate as an implied duty are not at all clear. Okay, as I earlier explained in the duties of employee. Okay, so it's very difficult to draw a line. What are the duties of employer? What are the duties of the employee according to law and also according to the implied term? Okay, so here the author also recognize okay, it's not clear at all. Okay, however, employer have a legal duty to treat his employees with due respect and also consideration, mindful of their needs and also the problem. Okay, so first we look at the duty of employer. Okay, so the general duty is that okay, um, the employer is not under any obligation to provide work for his employee. Okay, so even though you are an employer, you employed an employee. Okay, the law says that you are not under uh, obligation, under an obligation to provide work to your employee. Okay, so here the case, Collier versus Sunday referee says that provided I pay my cook her wages, she cannot complain if I choose to take any or all my meal out. Okay, so this case is about cook. Cook means tukang masak. Okay, so she cannot complain if the employer decide to take the meal outside. Okay, but she will be paid regularly. Okay, so this is a old case, but there's an exception where failure to provide work is breach of duty. Okay, according to Herbert Clayton's case, an actor was given leading role in a musical comedy, and he was subsequently given a lesser role, but at the same salary. Okay, so the court had that the employer was in breach of contract because the nature of the work was as important as the salary to be paid. So in a later case, the court says that you must give work to your employee so that they will can work. Um, I mean, they can work because the work will make them to increase their ability. Okay, so another case, Lanter's case, that if an employee need practice in order to maintain or develop their skill in employment, the employer is under a duty to provide a reasonable amount of work for this purpose. Okay, so you must give your employee work so that the employee can develop their skill. Okay, that's the reason. Okay, even though you must pay salary, you must also give work for them to develop their skill. Okay, so employer also have duty to compensate. Compensate, that means if anything happen to the employee, the employer have to compensate. That means have to pay. Okay, pay compensation. Okay, compensation to the employee. Let's say the employee was injured. Okay, or he met an accident. Okay, he have to pay compensation. Okay, so we look at this case, Joffrey versus Ford English case. The claimant was injured due to the negligent driving of the defendant, whose employer did not have a valid third-party insurance as required by the Road Traffic Act. Okay, so the employer have to pay compensation. Okay, then if any wrongful act for the employer was done, okay, and the employee was acting under the employer's order, the employee is also entitled to be indemnified for any personal loss he suffered. Okay, so if the employer asks the employee to do any action which is what do you call that make the employee suffer any personal loss. Okay, so the employer have to pay the compensation also. Okay, also English case, Reformatina Development Corporation. Here, the consulting engineer employed by the company was asked to prepare a report on the conduct of managing director. Okay, so the engineer was asked to prepare a report on the managing director, conduct of the managing director. Okay, so the managing director, okay, took an action for libel. Libel means fitnah. Okay, so the court had the employee was entitled to be indemnified by the company for his cost in defending the action, for he had been requested by his director to make the report. Okay, so it's very clear. Okay, he had to make the report Okay, and the report, of course, there will be some statement regarding the conduct of the managing director. Okay, then the managing director took action. So now the employee have to engage a lawyer to prepare the case. So the company must pay for that particular legal cost. Okay, so employer also have to make sure, okay, the safety of the employee. Okay, he have to ensure the duty, safety duty of the employee. Okay, so the duty owed by the employer in respect of the employee physical and mental health, including ill health, was discussed in many English cases. So it can be for ill health caused by overwork. It can be for psychiatric illness, or it can be like stress also. Okay, so the employer have the duty. This can be under the physical and mental health. Okay, and um, other safety can be for injury. Okay, like in Malio Wasta's case, while performing diving means activity menyelam. Okay, for the defendant, the plaintiff was injured. Plaintiff is the employee here. So the court had that the defendant company had failed to provide safe and proper system of work, as they did not provide second diver. A second diver means penyelam yang kedua, okay, at the scene, and also were negligent for unreasonable delay in bringing the plaintiff to the chamber after the accident. Okay, so you can see the duty for safety, okay, is not only for mental health but also for the injury. Okay, mental, physical, okay, and also for safety of employee. Okay, and there's also duty under OSHA. Okay, we will learn this topic later. Okay, under OSHA 1994. Okay, then the employer also have duty to write references, or maybe sometimes you want the employee to give a reference letter. Okay, so the employer has a duty towards the employee when writing references. So he must make sure that he take care to ensure that references were not misleading and should write them with care and skill. Okay, and we also got cases where, like Kit case, Kit versus Azhar Equity, the employer may be liable for any loss suffered by the employee as a result of inaccurate comments in the reference letter. Okay, so not much on duty of employer. Okay, so you can also read English cases for this because the duties of employer and employee is based on common law duties, and also those will be those mentioned in our statutes. Okay, so for the statutes we'll look later when it goes by according to the topics, like duty, what do you call, under social security. Okay, under social security law, and then we could also duties under the what do you call, terms and condition under the Employment Act. Okay, so when you go to certain topic, you will understand more what are the duties of employer and also employee. Okay, so it's nearly 3:50. Yeah. So do you have any question to ask regarding the duties of employer and employee? Okay, participants or students, do you have any questions? Oh, it's very long here. The profession when the company monitoring. Okay. Okay, so there's a question here. Is that profession when a company monitor its employee attitude through their social media accounts? Doesn't that consider a violation of privacy for the employees because they need to be careful of their act, even though it's outside the working hours or is part of this? Okay. It's like this. So we have one topic which we call as misconduct. Okay. So in misconduct, the employee have to take care their attitude at work and also outside their work and also their personal matters. Okay, so they must be very careful. If those days we can see that their misconduct is only related to workplace, but now is on their private misconduct also. Okay, they must make sure that even though there is their own business, we can say that, but if it affect the image of the employer can take action. Okay, and if you want to say that it violate the privacy of the employee, okay, so you must make sure that it does not relate to the workplace or the employer. Okay, so what they want to do is about themselves is okay, but they must make sure that they do not relate the employer or the working place or their organization in the social media. Okay, Nurul? Okay, so we got another topic on this. Okay, um, there was one case, where a foreign expertise was engaged by a Malaysian company. Okay, and the company gave him hotel to stay. Okay, that means he's well paid. But what this employer did, okay, is that he had a fight. He was drunkard and he had a fight in the hotel bar. Okay, and the company dismissed him because even though he was drunkard, he can drink. Okay, because it's not against his religion, he can drink. But what he did, that he had a drunkard, he was drunk and he had a fight at the place where the company provide him a hotel to stay. Okay, is where the court says that okay, it tarnish the image of the company. Okay, so the court conclude that his dismissal was fair. Okay, because the what do you call the reputation of the company was injured. Okay, so any question, students? Any question?
Madam.
Do you have any question? No. Can I end the class? So for the next class on Monday, I'll give you some instruction. Okay, what to do. Okay, and what to read. Okay, and also I will also let you know. Okay, how to find cases. Okay. So I was thinking to let you know this week, but since we have enough we already have 2 classes. I don't want to burden you more than that because our class is like 1.5 hour, and then I normally ask you all to scan the attendance earlier than that. Okay, so it's about, it's a bit like tiring. Listen to online for 1.5 hours straight away. Okay, so thank you. Okay, thank you to all. Okay. Okay, everyone.
Thank you, madam.
Thank you.
Thank you, Madam.
Thank you, madam.
Yeah, okay.